Neama, thank you for joining us today.
Defense counsel can ask the witness about why he's in jail, his offenses, and maximum penalty, but that's it. He can't go any further. What are your thoughts?
Yeah, I agree, Ashley. This is very common. We need to protect this particular witness's Fifth Amendment privilege against self-incrimination. His attorney is not there. So the last thing you want to do is to get into a potential appellate issue here with respect to this witness. You want to make sure that his rights are protected. And that's the judge's job, because obviously the state and the defense are just focused on their particular interest in this case.
That's right. How much does it affect the witness's credibility, though, when he's in before the jury? The jury's coming in the courtroom now, which is why they're on a little bit of break while the jury enters. While that happens, I mean, he is there in a jumpsuit as a witness. In your opinion, Neama, does that affect how a jury is going to receive his testimony?
No question, Ashley. You have a witness here who is in the orange prison guard. He's going to testify that he is in custody. They're going to talk about second-degree felonies. So that will absolutely affect his credibility. Jurors don't like felons, whether they've been convicted or not.
All right, they're rising. The jury's coming in. Let's go back to court. Assuming that objection might be asked and answered, because he has asked, but you didn't say in 2018 that he was boasting, he being the defendant, and happy. That's already been answered. What do you think they're going out to talk about?
There's certainly some evidentiary issue that's been discussed. Perhaps there was a statement that was admitted in part, and there's portions of which were not admitted into evidence. But obviously the fact that they're going back into chambers, it's probably something more than asked and answered, I believe, Ashley, on this particular objection.
All right, it'll be interesting to see. When I started to make it, I thought, wow, what a good pickup. That I agree, there was an inference that something negative was going to be said about the defendant in this case, and the defendant's the one who's been convicted, Andre Warner. Neama, what were your thoughts as the defense was making that motion?
Ashley, when we first heard Denzel Rakowski talk about Andre Warner's statement, we assumed that this is something that had already been dealt with pretrial motions, but it seemed to catch everyone off guard, including the state prosecutor. So obviously they had no idea that Denzel was going to talk about Andre Warner's statement. So setting aside the statement, I agree with Joy, and I really like the arguments that the state made here. I mean, jail calls have been admitted. This is a very rare and unique case where guilt and penalty are being decided by two completely different juries, and this particular jury knows that Warner's already been convicted of first-degree murder. So, to the extent that there was discussion of him being in custody or being in jail, though it was arguably improper, it's certainly not grounds for a mistrial. With respect to the statements that Warner made, again, I think it's too much of a leap to say that the statement would have been negative. Again, not grounds for a mistrial in this case. I like the defense's argument, but I really, really like the state's response there too.